The Danish Data Protection Authority, Datatilsynet, has imposed a ban on the use of Google Chromebooks and Google Workspace in primary schools in Helsingor Municipality, citing non-compliance with the General Data Protection Regulation, GDPR. The ban, which took effect immediately, requires the municipality to withdraw and terminate processing, as well as delete data already transferred to the United States. This decision is rooted in the fundamental principles and requirements of the GDPR, particularly those related to lawful processing, transparency, accountability, and data controllers' responsibilities. The Danish DPA's decision is also influenced by the Court of Justice of the European Union's (CJEU) judgment in Schrems II, which emphasizes the need for strict requirements to be met when transferring personal data to third countries outside of the European Economic Area (EEA). The GDPR restricts such transfers unless specific conditions are met, including adequacy decisions, appropriate safeguards, and derogations. In this case, the municipality failed to demonstrate compliance with these requirements. The European Data Protection Board's (EDPB) recommendations on measures to supplement transfer tools, adopted on November 10, 2020, were also considered in this decision. The new standard contractual clauses, SCCs, for data transfers, which supplement existing safeguards, are now the applicable requirements. Article 2, on which this ban was established, examined general principles regarding transfers. Per relevant CJEU conclusions, international controllers needed reassessed approaches involving critical concern post-Schrems II. Inherent European countries must either contract protection directives implementation against greater violations data requirements while operating duties assessments accordingly provide access limitations resulting evaluations decisions mechanisms do implemented directly monitoring real estate country members ensuring handling private relations conduct imports external operation locations actions internationally protect worldwide levels even out where applying when particular nation users individual interest prior operation obtaining services need state sharing lawful consideration safety essential analysis taken needs certain applying public space governance regarding export systems impacts others levels. Data-related public standard impact effects more still for outside results changes where issues considering following their due guide ID external context compliance considered use call check is review local and required regarding major importance being from on process these using approach privacy systems governed no extra existing analysis now assessment management scope they share ongoing interest applied those operating European or final nature levels rights ECHR evaluation RUS I can summarize and better convey your written feedback within an allowance word count stipulation when trying bridge distinct arguments out especially doing little bridges work required understanding feedback summaries trying move very targeted required and clear open requirement getting inside perspective less explicit step processes although significant might slightly summary should express point taking issue all extra including of like providing said has non-part place was text style type IIK. Text adjusted significantly summarizes existing stipulation going. The Schrems II case has significantly raised the bar for organizations seeking to comply with the complex legal landscape of cross-border data transfers. The Court of Justice of the European Union, CJEU, invalidated the EU-US Privacy Shield framework and deemed standard contractual clauses, SCCs, as a valid tool to enable GDPR-compliant transfers of personal data, provided supplementary measures are in place to compensate for potential data protection deficiencies in third country laws and practices. These supplementary measures aim to ensure that personal data will be adequately protected under essentially equivalent European standards. The European Data Protection Board, EDPB, recommendations and the new version of the SCCs have clarified the organizational and technical measures that data importers and exporters must implement. The EDPB suggests a six-step approach, which includes a more detailed explanation of supplementary measures, such as pseudonymization and encryption, as well as specific use cases demonstrating effective supplementary measures. These include situations where data is fully encrypted with keys controlled by the data exporter or an entity trusted by the exporter in the European Economic Area, EEA, effectively pseudonymized data, and reliance on split or multi-party computation. Moreover, the EDPB emphasizes the importance of assessing the third country's law and practice to establish whether personal data will be adequately protected. This requires a risk-based approach and the performance of a transfer impact assessment (TIA). Data exporters must collaborate with the data importer to assess the third country's legal framework and practice, considering factors such as the nature of the data, the purpose and duration of the data transfer, the legal framework of the third country, and the technical and organizational measures implemented by the data exporter and importer. In conclusion, the Schrems II case and subsequent regulatory attempts have reshaped the legal landscape for cross-border transfers of personal data. The emphasis on supplementary measures, risk assessments, and the need for a case-by-case evaluation of third-country laws and practices underscore the importance of ensuring adequate protection of personal data under essentially equivalent European standards. This has significant implications for organizations operating internationally, necessitating careful consideration of data protection safeguards and the implementation of robust supplementary measures to maintain GDPR compliance. The assessment of third-country data transfers under Article 46 of the General Data Protection Regulation, GDPR, necessitates evaluating the legal system of the destination country to ensure the effectiveness of safeguards. This involves considering aspects such as lawful access to personal data by public authorities. If the transfer impact analysis reveals the mechanism is not effective, data exporters and importers must implement additional safeguards on a case-by-case basis. In the context of the Danish Data Protection Authority (DPA) decision, the use of Google Chromebooks and Workspace in Danish schools raised concerns about personal data processing. Specifically, the Helsingor Municipality case involved students using Google Apps and later Google Chromebooks and Workspace, granting access to programs like Gmail and YouTube without parental knowledge or consent. Personal data, including names and school information, were processed and displayed on these platforms. The Danish DPA investigated a complaint from a parent whose child had created a YouTube account without consent, potentially publishing personal data. The municipality confirmed the complaint but argued the risk was low and did not conduct a Data Protection Impact Assessment (DPIA). The Danish DPA ordered Helsingor Municipality to perform a risk assessment and impact analysis of its processing activity, which involves personal data flows in primary schools using Google Chromebooks and Workspace. Notably, the municipality uses Google Cloud EMEA Limited as a data processor, and the Danish DPA suspended personal data transfers to the US instructed by Helsingor Municipality. The decision highlights the importance of conducting thorough risk assessments and impact analyses to ensure adequate data protection, particularly when using third-country data processors. The Helsingor Municipality's data transfer to Google LLC in the US was suspended due to concerns regarding the effectiveness of standard contractual clauses, SCCs, in ensuring the protection of personal data. The municipality had implemented SCCs as a transfer basis and prepared a transfer impact assessment, TIA, following the Danish Data Protection Authority, DPA, and European Data Protection Board, EDPB, recommendations. The TIA assessed the risk of US authorities accessing personal data, concluding that the risk was more theoretical than practical, with a 50% probability. However, the TIA also revealed that personal data transferred to Google LLC in the US would be available in plain text, despite Google's use of encryption and pseudonymization. Google personnel could access the municipality's personal data, as they held the decryption key. This meant that the municipality had no complete control over the access of personal data in the EU data center. Regarding the legislation and practice in the US potentially impinging on the effectiveness of the SCCs, the TIA noted that Google LLC may qualify as an electronic communications service provider under Section 702 FISA. However, the municipality argued that the data accessible to Google LLC was excluded from access under Section 702 FISA, as it was not transmitted by but to Google for support services. Additionally, the municipality's personal data did not comprise data about US persons, and US authorities were thus barred from accessing data under Section 702 FISA. Despite the municipality's risk assessment, the Danish DPA found that the risk to the rights and freedoms of the registered pupils was too high, and the processing did not comply with the GDPR requirements. The DPA criticized the municipality's data processing practices, including the transfer of data to third countries for technical support without adequate security and protection. The DPA decided to ban such processing for violating the GDPR and suspended any related data transfers to the US until it was brought in line with the GDPR. The main risk identified was processing personal data for other purposes, despite Google's role as a processor and the data processing agreement signed with the municipality. The Danish Data Protection Authority, Datatilsynet, has imposed a ban on the use of Google Workspace in Helsingor Municipality, citing violations of the General Data Protection Regulation, GDPR. The decision was based on an assessment of the risks associated with the data processing construction and system choices made by the municipality. The risk assessment highlighted several concerns, including the potential for Google to break contractual obligations and use personal data for marketing or other unintended purposes. It also pointed out the risk of transferring data to third countries, particularly the US, where problematic legislation could compromise the rights and freedoms of data subjects, especially students who enjoy special protection under data protection rules. The Danish DPA noted that the municipality's encryption measures were insufficient to mitigate these risks, as Google LLC may still have access to information in plain text. Furthermore, the municipality failed to conduct sufficient testing of the hardware and software used, and did not document how they controlled Google's access to personal data. In a subsequent decision on August 18, 2022, the Danish DPA maintained the ban on the use of Google Chromebooks and Workspace, concluding that the municipality had not successfully documented measures to reduce the high risks for children in Helsingor Municipality's schools. The Danish DPA's findings underscore the importance of thorough risk assessments and the implementation of robust safeguards to ensure compliance with Chapter 5 of the GDPR, particularly in relation to cross-border data transfers and the protection of sensitive personal data. The Danish Data Protection Authority, DPA, has emphasized that Helsingor Municipality has not adequately assessed and mitigated the risks associated with its contract with Google, particularly regarding the processing of personal data. The DPA believes that Google acts as an independent data controller, processing personal data for its own purposes, contrary to the municipality's assessment. This decision highlights the need for municipalities to carefully evaluate the risks associated with data processing, especially when using cloud computing services. The Danish DPA has identified several areas of concern, including unauthorized disclosure and transfer of personal data to third countries. To address these concerns, municipalities must conduct a transfer impact assessment, TIA, to demonstrate that the transfer is not subject to problematic legislation, such as FISA 702. Moreover, investing in risk assessment software tools, following the privacy by design and by default approach, can help mitigate practical challenges. However, contractual and organizational measures alone are insufficient, as they do not render ineffective access to personal data by U.S. law enforcement authorities. Technical measures, such as full encryption, pseudonymization, and split processing, are considered the most effective supplementary measures to ensure the security of personal data. This is particularly relevant when using cloud computing services. The Danish DPA has provided guidance on the use of clouds, emphasizing the need for technical measures to protect personal data. Municipalities are expected to take relevant actions and develop strategies to manage these legal risks, including assessing whether similar problems exist and, if so, cooperating with suppliers to regain control of the processing. By implementing these measures, municipalities can ensure that their equipment and tools are used in accordance with the law. The Danish DPA's decision has significant implications for municipalities using similar Google tools with a similar processing structure, emphasizing the need for careful risk assessment and mitigation. In the context of overcoming data protection limitations and ensuring secure data analysis, one approach is to employ technical solutions such as multi-party homomorphic encryption. This method combines secure multi-party computation, allowing for the querying and analysis of encrypted data without the need for decryption. This approach would enable municipalities to scale and effectively protect data, providing a more robust alternative to current data protection measures. Another emerging technology-driven solution involves storing data in the end-user's personal cloud, following the user-held data model. This approach grants individuals greater control over their data and significantly reduces the need for unnecessary open-ended cross-border data transfers. Users could choose their geographic location and keep their data stored locally within the EEA in a more decentralized manner, thereby enhancing data privacy and compliance with legal frameworks. The research for this paper was supported by a Novo Nordisk Foundation grant for a scientifically independent collaborative research program in biomedical innovation law. The paper cites various sources, including a full account of homomorphic encryption, supplementary measures and appropriate safeguards for international transfers of personal data after Schrems II, and the future of international data transfers with a user-held data model. These sources provide further insights into the technical and legal aspects of data protection and privacy, highlighting the complexities and challenges involved in ensuring compliance with data protection laws while facilitating data analysis and sharing. The paper concludes by emphasizing the importance of exploring novel solutions to address these challenges, particularly in the context of international data transfers and privacy-preserving data analysis. It underscores the potential of homomorphic encryption and user-held data models to enhance data protection and compliance with legal frameworks, while also enabling effective data utilization for various purposes.